whatever the person may have thought or wondered their sexuality was. So she sued. She lost in the lower courts, and today, in an 8-1 decision, the Supreme Court reversed those courts and handed her a major victory under the First Amendment. The court said that this law, as applied to her, discriminated based on her viewpoints, and that it prevented her from actually having these conversations with her patients, talk therapy only, and that violated the First Amendment. And there's a really powerful quote I want to read to you from Justice Gorsuch, who wrote this opinion for the 8-justice majority. It said, cases like this censor speech based on viewpoint, but the First Amendment stands as a shield against any effort to enforce orthodoxy in thought or speech in this country. The argument being that this kind of law prevented people from having conversations with their clients about any kind of sexual orientation or gender identity issues. Justice Ketanji Brown Jackson is the lone dissenter, which I think is not surprising. She kind of tipped her hand at those oral arguments back in October that she thought that states could regulate this kind of speech as medical treatment, as conduct, that it didn't amount to kind of any kind of free speech issue. So right now, what this means is a big victory for this Colorado Springs therapist and how the state was kind of seeking to apply the law that affected her counseling practice.
And Jan, an 8-1 decision is relatively unusual. You can fact check me on that.
That's right.
Why do you think it was such a clear decision on this specific case?
Because this is a very narrow case. I mean, they're not striking down this law. They're saying that the way the state of Colorado could have potentially applied it to this therapist would have violated her First Amendment rights by limiting what she could talk about with her clients in those private sessions as they were, again, struggling with sexual orientation, struggling with their gender identity. All she could do would be to affirm those kind of thoughts. And she argued that was unconstitutional. The justices today, I think sometimes we see this, especially in First Amendment cases, can kind of tend to come together on some of these issues, obviously very concerned about speech that cuts both ways, Errol. You know, liberals and conservatives can see the impact when you're trying to suppress speech and how that can have an impact on the greater discourse. So we'll get through the dissent, but based on the arguments, Justice Jackson was, again, very concerned that this was just conduct and that states could regulate it and that not being able to do so could cause some real harm.
All right, Jan Crawford's notifications flying off the hook for good reason. You're the best person to talk on this topic.
I forgot to turn my phone off.
No, we understand the struggle, Jan Crawford, with the latest.
The news is breaking, Errol. The news is breaking.
That's right, and that's why folks are watching it here first on CBS News 24/7. Jan, thank you very much.
Thanks.
All right, joining us from LA this morning is CBS News legal contributor Jessica Levinson. So, you know, we just were talking with Jan. Errol mentioned it's an 8-1 decision. This was really about the First Amendment, sort of that narrow piece of this at the heart of this case. So break down what's the significance of this.
So I just want to echo everything Jan said. Yes, yes, yes. When it comes to this case, the biggest decision that the court made is that we're talking about speech, not conduct. That puts us into an entirely different framework when it comes to the First Amendment. It means we're really worried about the government regulating us. Now, once we decide, yes, we're talking in this case about this Colorado law, about speech, what type of speech, what type of regulation on speech are we talking about? The worst type of regulation, meaning the one we're most worried about. It's not just regulating the subject matter of what we're talking about, which is bad enough, but the court, by an 8-1 majority, says we're talking about the viewpoint of what people are saying. That is what we are most concerned about when it comes to regulating speech. And that's why I think Jan was so right to point out many of these cases break down in ways that are sometimes unusual. And frankly, sometimes you see the court much more united than you might expect. So what we have is a court who thinks that this particular law limits not just the subject matter people can talk about, but the view they can express. Again, this is where historically the First Amendment is the most robust. That's why we have almost every justice saying, apply a higher level of scrutiny. Go back lower courts as applied to this woman and apply the highest level of scrutiny that you can use. And we should be clear that that is almost always fatal to a regulation. Once you really use strict scrutiny, it is extremely rare for any law to satisfy that. The one instance I'm thinking about are limitations on basically electioneering outside of polling places and ballot boxes.
And so just to summarize for our viewers, Jessica, who may not be aware of the case or the issue, Colorado had banned conversion therapy, which aims to convert someone's sexual orientation or gender identity when the patient is a minor. So it limited certain conversations between therapists and patients. So now with this decision, what happens to that?
So, Errol, thank you for, again, summarizing what we're actually talking about as I'm diving into First Amendment and the different tests that we use. So what this means is that anybody who is similarly situated to this plaintiff will be able to say, as applied to me, this law can only work if it survives strict scrutiny. And I think it's very unlikely that laws will be able to survive strict scrutiny. Or maybe, frankly, more simply put, I do not think that this law and similar laws, because this is a First Amendment decision, so it applies across the country, I don't think similar laws will be able to be in place when it comes to this situation of somebody coming to a therapist to talk about so-called conversion therapy. I think this will essentially wipe out those laws, again, in these situations.
All right, important context. Jessica Levinson, thank you so much for joining us and breaking down this breaking news.
Thank you, Jessica.
All right, CBS News legal reporter Katrina Kaufman has more from right here in the CBS Broadcast Center. So we've been talking about this as 8-1, right? So there was one dissent that came from Justice Jackson. Can you break down for us why?
That's right. And I want to reiterate everything that Jessica and Jan said, but it is very interesting to look at this split. And just to explain it a little bit, the core issue here was, is this First Amendment right? This speech that goes on during these talk therapy sessions about conversion therapy, or was this Colorado law banning the discussion of conversion therapy, regulating professional conduct? Now, 8 of the justices decided that this was viewpoint discrimination, that this was a violation of the First Amendment, as you were just talking about with Jessica. But Justice Jackson feels otherwise. She says that the majority is failing to appreciate the crucial context of this. She said that no one disputes that conversion therapy is harmful, and she talks in this dissent about how no one also disputes that Colorado has the power to regulate medical treatment. So her whole issue here is that conversion therapy is harmful, and she clearly views it as a regulation of a medical treatment, as opposed to this First Amendment view that the rest of the court took here.
Please.
All right, Katrina, really appreciate that. We want to stay on this piece about dissent. I want to go back to Jan Crawford. Jan, you've been listening to Justice Jackson. She's actually speaking right now, I think, about the dissent. Can you give a little bit more color on what you're hearing?
Yeah, we're hearing from our colleague Melissa Quinn, who is at the Supreme Court right now to get this decision, that Justice Jackson is summarizing her dissent from the bench, and that is extremely unusual. Rarely do justices summarize their dissents from the bench. It has to be typically a much more significant case than this one, and one where there is much sharper divide. So for a justice to summarize their dissent from the bench shows that she obviously, as Katrina signaled, has a strong disagreement. And going through her dissent right now, she's using words like catastrophic to describe what impact it could have, not only on therapy sittings, but the entire medical profession, and how it will jeopardize states' ability to actually regulate the practice of medicine. Obviously, 8 of her colleagues disagreed with her. And why I think this is interesting is not as much kind of the content of this decision, but it shows the path that Justice Jackson is setting out for herself on the Supreme Court. She is signaling that she is willing to be a solo voice, perhaps the most liberal justice, and whenever she has any disagreement with her liberal colleagues, she's going to speak out about it. That's why we see her take up so much time during the oral arguments with questions. She is the most, as the junior justice, active questioner on that bench. She also is the justice who writes the most frequently frequently when she has disagreement with her liberal colleagues. So again, today, I think it's just something interesting for us kind of Supreme Court nerds to follow. Having her summarize that dissent from the bench is very unusual in a case like this, and signals, I think, Justice Jackson, if we didn't know it already before, is a justice that is going to go her own way and really not care about as much about some of the court's traditions and kind of collegiality that perhaps some of her other colleagues may.
Fascinating detail, Jan. And as you told us earlier, they are not striking down Colorado's conversion therapy ban necessarily on the grounds of the First Amendment. So it has nothing to do really with the content of this therapy ban and more on just the concept itself of the First Amendment. Why do you think it's so important for Ketanji Brown Jackson, Justice Jackson, to be the lone dissent, to avoid a 9-0 decision? And if she's teeing up something next, what might that be?
You know, that's a great question, Errol, because, you know, again, what I think is the language is pretty fiery in her dissent, but that's typical of all of her dissents. I mean, she often is the solo dissenter because she does use kind of this incendiary language to signal her disagreement. So that's not unusual. She's also worried about the impact of the medical profession, like I said. Again, that's not surprising. She signaled that at oral argument. So I think it could be signaling to your bigger question what we can expect in these cases ahead, which are much more significant. Obviously, this is an important case. It'll affect a lot of people. There are 25 other states that have similar laws that won't be able to apply them now as broadly as perhaps Colorado may have wanted to. It's not striking them down, but it will limit how they can use them. But it's going to be interesting to see on some of these other big cases, voting rights, transgender sports, how she's going to go her way.
I love that you're able to provide that context. We love that you're a Supreme Court nerd, Jan, okay? Because we benefit from it. You know, you mentioned some of the cases ahead. I do, before you go, if you could just quickly preview what we're expecting tomorrow. We're going to hear arguments in that very important birthright citizenship case.
President Trump, with an executive order, is trying to redefine how we've long thought about what it means to be a citizen in this country. It's hard to imagine anything more foundational than that. He's challenging kind of this long-held assumption that if you're born on U.S. soil, you are a U.S. citizen. He's saying in this executive order that if your parents were here illegally or temporarily, that you are not a citizen, that you are not under the jurisdiction of the United States, as it says in the 14th Amendment. And that would be, I think, as we can all recognize, a pretty revolutionary change. And I will be very surprised if these justices go along with it. We will see more tomorrow. You can often get an idea of how the court's going to rule, like in this case today, based on the questions that the justices ask. So I'm really excited to see what we're going to hear from those justices tomorrow when the Trump administration starts making these arguments in that majestic courtroom, starting in the morning at 10 o'clock.
Yeah, it's all so fascinating. We'll let you address those dozens of texts and calls that have just come across your device. Jan, thank you so much. Our thanks to Jan, Jessica, and Katrina. We'll be back in just a moment. Stay close.
Go to the ends of the earth.
We'll hit the heights.
A great adventure together.
And reach for the stars.
Star power. I like it.
So cool.
But wait, there's more.
Experience thought-provoking,
something that's undeniable.
With mindfulness.
Innovative,
magical.
It's like being a child.
And truly original reporting.
God, you do your research. I tell a good story.
Because there's always something new under the sun on CBS Sunday morning.
The 18-year-old soccer